Good morning, everyone. Welcome to the Judicial Committee hearing. My name is Carl Rhodes. I'm chair of the committee. This meeting and YouTube live stream event will include the following agendas and our 9:30 agenda. Hearings being streamed live on YouTube, and you can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website at capitol.hawaii.gov. We have a catastrophic technical failure. We'll reconvene on Tuesday, March 22 at 9:25 in this room in a video conference to pick up any business that we didn't get to. And for those testifying remotely, you'll be muted and video off until it's your turn to go. And we do have a 2-minute time limit on testimony. I think that's it for the preliminaries. Let's go ahead and start with our first bill is our first measure is a governor's message 591. Submitting for consideration and confirmation to the statewide voters with special needs advisory committee gubernatorial nominee Ramota Anand for a term to expire 6/30/24. First up on GM 591 is Reverend TJ Fitzgerald for First Unitarian Church of Honolulu. Good morning. I think you're muted. There you go.
Good morning, Chair and committee. It's an honor to be here. Thank you for your time and your attention. It is one of my great honors of really my career and my work and serving our community to support the nomination of Mr. Ramota Anand for this position. He has served the islands of Hawaii for more than a decade in ways that have improved the lives of not just those who ambulate or move differently, but for all of the citizens of this state in a way that is compassionate, effective, courteous, full of good humor, good cheer, and is really one of the best examples of someone I can imagine doing public service here. So I'll share the rest of the time and just say I wholeheartedly support his nomination. We'll also be standing by to assist with any interpretation needed. Okay, thanks everyone.
Thank you very much. Next is Daintree Bartoldas, Executive Administrator for the State Council on Developmental Disabilities and Support, Hawaii Self-Advocacy Council and support, Lee Curran in support, Kathy Gilliam in support, Ms. Jill Robina in support, Nancy Young in support, Esther Gale in support, Carla Allison in support, Kevin Launders in support, Carolyn Eaton in support, Francine Less in support, Allison Jacobs in support. And that's all the testimony we have on GM 591. Mr. Anand, would you like to make an opening statement?
Thank you very much for the honor. I look forward to the work on the committee with aloha. Thank you again.
Peace, everyone.
Peace, everyone. Thank you. Eulalia is also with Mr. Anand.
All right, thank you very much. Members, I forgot to ask if anybody had questions for the testifier that's here, Reverend Fitzgerald. Any questions for Reverend Fitzgerald? Okay, if not, any questions for the nominee? I have none either. Thank you very much for being here. Members, if it's okay with everybody, let's go ahead and vote on this one so the nominee can leave without having to wait for the entire agenda. So the recommendation on GM 591 for the statewide voters with advisory committee for a term to expire 6/30/2024 for Mr. Ramota Anand is to advise and consent. Questions or concerns? If not, Vice Chair.
Members voting on Governor's Message 591, the recommendation is to advise and consent to the nomination. Chair Rhodes?
Aye.
Vice Chair goes aye. Senator Ocasio?
Aye.
Senator Gabbard?
Aye.
Senator Kim?
Aye.
Senator Lee?
Aye.
Senator Favela?
Aye.
Recommendation adopted.
Thank you very much, members. Thank you, Mr. Nan, for being willing to serve, and congratulations. There'll be a full Senate floor vote soon. Okay, members, let's go. Thank you. Let's go ahead and move on to the next item on the agenda, which is HB 1471 relating to political parties. This amends provisions relating to dates and deadlines and statutory provisions regarding political parties. First up on HB 1471 is Scott Nago, Chief Election Officer. Good morning.
Good morning. The Office of Elections will stand on its written testimony and support and be happy to answer any questions. Thank you.
Okay, thank you, members. That's the only testifier we have on 1471. Any questions? I have none either. Let's go ahead and move on to HB 1472. This amends the information necessary for a voter to withdraw their signature from a petition under election laws. First up on 1472 is Scott Nago.
Good morning. The office will stand on its written testimony and support and be happy to answer any questions. Thank you.
Thank you. That's the only testifier we have on 1472. Members, any questions? I do have a question for you, Mr. Nago. So what all are petitions? Which petitions are we talking about?
So we're talking about petition.
There's one for qualifying political parties. I'm aware of that one. Are there others as well?
Presidential petition to be placed on the ballot as a presidential candidate. So you can be either two ways. You can be nominated by a qualified or recognized party, or you can petition to be on the ballot.
Okay, so those are the only kinds of those are the only two kinds we're talking about.
Correct.
Then. Okay, all right. Thank you very much. We'll go ahead and move on to the next bill, which is HB 2049. This is the statutory revisions bill. First up on 2049 is John Morsey for Legislative Reference Bureau. Good morning.
Good morning, Chair. We stand on our written testimony and support, and I'll be available for any questions.
Okay, thank you. That's the only testifier we have on HB 2049. Members, any questions? Seeing none, thank you for being here. We'll go ahead and move on to the next bill, which is HB 2069 relating to gifts. This establishes procedures for the custody, inventory, and care of protocol gifts. First up on 2069 is Kurt Otaguro, State Comptroller. Doesn't appear to be here. In support, Yiju Soon for DAGs. Also doesn't appear to be here. Also in support, Sandy Ma, Executive Director, Common Cause. Oh, okay. Sorry, we'll back up. Jusun Yi. We can't hear you. Still can't hear you. Why don't we do this? If you can try to figure out your I do have some questions for you. So if you can try to figure out your technical difficulties there, let me go to Sandy Ma first, and then we'll come back. Okay. So for Sandy Ma, Executive Director, Common Cause Hawaii.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We support HB 2069. Protocol gifts should be kept by the state archives for all of Hawaii to enjoy instead of the individual who received this protocol gift. Thank you very much for allowing Common Cause to testify in support of HB 2069, and I'm available for any questions. Thank you.
Thank you very much. Okay, we'll try to go back to DAGs for Jusun Yi. Still can't hear you, I'm afraid. Sorry, can't hear anything. Okay. What about, I don't know, you're using a laptop. Does it have a volume control on the side? No, okay. All right. Well, if you figure it out, interrupt and let us know, because I do have some questions for you. But for the moment, members, any questions for Ms. Ma? If not, we'll go ahead and move on
Can
to,
I just raise a question or concern?
yeah, sure, go ahead.
Okay, so on page 3, it says a state employee or member of either house of the legislature shall transfer the state archives any protocol gift within 30 days of receiving the protocol gift. Having been Senate President, I'm very familiar with dignitaries bringing in a protocol type gift, and normally.
Hang on a second. Yeah, I think we heard you there. Say something again.
Sorry, hello?
Yes,
Can you
okay.
hear me?
Yes.
Oh,
hang on
okay.
Just one second. I'll
Sure,
let Senator
sure.
Kim finish and then we'll come to you. Thank you.
Sure, sure.
and-
Thank you.
And normally these visitors may come during the session or come back, and they like to see that their gift has been displayed somewhere within, we had a display case. And so I just hope that we can somehow look at that and make it somehow practical, so that these kinds of gifts can be
Understood.
appreciated and displayed for a period of time within the 30 days that it has to be transferred over.
Okay, understood. Okay, Ms. Yee, go ahead.
Yes, sorry about that. My name is Ju Sunny. I'm the Deputy State Archivist here on behalf of the State Comptroller. So DAGs do stand on its written testimony, but if you have any questions, I'll try my best to answer them or forward them to the State Archivist who couldn't be here.
Okay, thank you. Members, any questions for Ms. Yee? I do have a couple. Let's see. So the reference to state employee that are covered by the proposed protocol gift procedure isn't entirely clear. Does it mean that any state employee or only an employee of the legislature? Are you trying to cover the whole state, or are you trying to just cover us?
I guess the way it's written in the bill, it is all state employees, but the definition of what a protocol gift is pretty defined. So we just included all state employees because they're also acting on behalf of the state. So
Okay,
in
so
that
you-
sense,
You
Go
want to
ahead.
cover all, you want to cover all state employees?
yes, as the way it's
Okay.
written here.
Okay, then the section that has to, it's a page 5, line 16, the section that has to do with gifts that are excluded from the reporting we have a normal gift law, a gift reporting requirement. I guess
Yes.
everybody does, but the legislature is the one I'm familiar with. It's by specifying that only non-protocol gifts that are returned are excluded. I think that would mean that protocol gifts are to be reported under the, so if you actually took the gift, then you would have to, I mean, you're not taking it yourself, but if you accepted the gift, it sounds like you would have to record it on your gift log, even though it really wasn't for you.
From what I understand, this would be kind of a separate inventory because of the definition of what a protocol gift is. So based on that definition, that's what would be recorded. If it's a gift under, for example, within the guidelines of the Ethics Commission, how they define a gift, then that would be going through that process.
So you would see these gifts as excluded from the normal gift reporting.
Right, because they first have to be defined as a protocol gift, which is on page 4. So specifically from the donor to the person receiving it within that definition.
So should there be some kind of a reporting? I mean, should there be some kind of protocol gift reporting system then separate from the gift reporting system, just so that?
Yes, that's what we're proposing, that these protocol gifts are reported, and then based on when the office would like to turn over these gifts to the state archives. I know that somebody had testified as saying that to have these gifts given to us within 30 days, but we don't feel that's necessary. We believe that they should report it first, and then at a time that they feel that it's appropriate, then they would transfer to state archives.
Okay. So I guess what you're saying then is that the you view reporting it to DAGs or to the archives that the protocol gift has been received. You view that as the reporting for those
Yes.
gifts. Okay.
Yes.
Well, the other question I had was, does the judiciary have its own system for reporting gifts like this? I'm sure they get protocol gifts from time to time too. Is your expectation this would apply to OHA, judiciary, executive, and legislative branches?
I'm not privy to what the process is with the judiciary system, but as outlined by the bill, because they're part of the state and employed by the state, I imagine this would apply to them. But as far as specifics, that I couldn't answer.
Okay. Okay, so you raised an interesting point about how long the initial recipient of the gift gets to keep it on their bookshelf or whatever.
Yes.
Let me turn it over to Senator Kim, if you wouldn't mind describing what you talked about before. And I think we're of one mind on that, but let's just double check.
Yeah, I was just saying that as Senate President, I would receive a number of protocol gifts from visitors, especially like our sister state city or state, and they would come year after year to our opening day or throughout the year, and they like to see their gifts being displayed. So I'm glad to hear that you're saying that we need to report it, but then at a particular time that's appropriate to, then it should be turned over. I mean, you know, some of these gifts I don't care to display, but you want to display it because you don't want to disrespect.
Right, exactly.
Yeah, and especially Asian countries, they really have this sense of wanting to see the gifts that they give you. But I do have a question regarding what is the reporting process or mechanism? If I just send you an email to archives says, I got this gift that satisfies it, shouldn't there be some kind of process that is being followed? I don't see that spelled out in the bill.
Yes, you're correct. Well, we anticipate that we would generate this form. So similar to how records are transferred currently to the state archives, there would be a similar form specifically about these protocol gifts. So we would work with the office or the agency that has these gifts and how to report them. So there would be a standardized form that we would give. And that way everybody would be consistent in terms of what information they provide. And then that way, that would also help us to organize these transactions or when these gifts are received. But yes,
Now,
definitely there will be a form.
Okay, one more question, Mr. Chair.
Yes.
So when these gifts are turned in, is there a way that others will know what these gifts are and have the opportunity if they would like to display it in their offices? I mean, is it just goes to archives and just gets put into a closet and collect dust? Or is there some mechanism by which these gifts are going to be displayed, utilized, whatever?
Right. Once the gifts are received by the state archives, I mean, it will be accessible to anyone that as far as if another office.
Could you say that again? A couple of critical words dropped out.
Oh, okay. Once the items are transferred to the archives, it will be accessible by the public as well as other state offices. We currently do loan things out. So we do have some artifacts, for example, that's on display at Iolani Palace or on display at Washington Place.
So just like the artwork that.
Yes, exactly. So
Okay,
that's
thank
something
you.
that would be worked out with the state office that's requesting it.
Okay,
But
thank
we
you.
would make sure, yeah. Okay.
For Ms. Moss, so I think you were one of the proponents of having them turned over within 30 days. Is that correct?
Thank you, Chair. Yes, that is correct.
So you've heard the discussion here between Ms. Yee and Senator Kim. Would you object to having a longer period so that basically to fulfill the purpose of having protocol gifts in the first place?
We would object.
You would, okay.
Yes,
All right.
because we're concerned about any appearance of impropriety there. We had previously suggested that if there needs to be maintenance of this relationship with a sister state or a sister nation, that still the protocol gift be immediately logged with the state archives and then signed out as the archivist has said to be checked out.
Okay.
Thank you.
Thank you very much.
I misunderstood that.
Senator Favela, go ahead.
So you're saying within 30 days, you turn in the protocol gift and then you check it back out? I never understand that last part.
Thank you, Senator Favela. Yes, so that there is a record that the gift has been logged in with the state, and then there's a record of you checking it back out, so that there is this notice to the state and to the public, instead of just at the end of the year, this record, this piece of paper gets turned in, or at the end of your term, this piece of paper gets turned in saying that there's a protocol gift, and the public doesn't see this protocol gift.
I understand that, but see, what Senator Kim and what I interpreting is that as long as we log them in with the archives, let them know that we got this gift on this and date, and we put them up, we go check them in and check them out. I mean, I don't understand. The email would have been suffice, and even a picture of the item, giving them to archives and saying, hey, we got this gift. We'll probably have it for throughout the session because it was given by whatever, who is in a community or country. And then at the end of the session, we take them in. I mean, I'm not understanding if you know what goes on over here to when you get stuff like that and every other thing, you're going to be turning them in, then you're going to go over and check them back out. I mean, it's not a library. You know what I mean? So it's going to be a little bit more difficult than what you think it is, especially if you set it president and you get about 30, 40 stuff like that to be displayed, and you will take all 30 of them, check them in and check them out. I mean, it sounds easy, but it doesn't, I don't see it's practical that we can do it at the end of the session, turn them in. And if president or any of the colleagues here want to re-display it, then they can check it out again. But to do it 30 days and check it in, I mean, the thing just got to your office and maybe the person that gave you the gift is still flying in. And by the time they get to Hawaii, the gift is back checked in and not even checked out yet. You understand? I mean, 30 days is a very short period of time when you get something that is sentimental to some of these countries or families that give stuff to be displayed in your office. So that's just my point of view. Thank you.
Thank you.
Thank you,
Senator
Chair.
Favela, I don't mean any disrespect. We want to preserve the ethics and propriety throughout the state, and we want to improve upon it. And so those are the suggestions of Common Cause Hawaii. I do not mean any disrespect to you or your staff. So thank you for allowing Common Cause to testify on this matter. Thank you.
Thank you. Members, any other questions? If not, let's go. Thank you for being here, testifiers. Let's move on to the next bill, which is HB 2074. Clarifies that defendant shall not earn credit on a sentence imposed for a subsequent conviction for the time being served on a previous felony conviction. First up on 2074 is Lance Goto, Deputy Attorney General. Or yeah, that's first. Is Mr. Goto here? Oh, there you are. Good morning.
Good morning, Chair. Good morning, committee members. Lance Goto with the Department of the Attorney General in support of this bill. Purpose of this bill is to amend section 706-671, subsection 3, to clarify that a defendant who's been convicted and sentenced to imprisonment for an offense and who subsequently, while in prison, commits a new offense, does not get credit for the pre-sentence detention time that the person is serving for the new offense, while the person is still incarcerated for the prior offense. This is consistent with the stated legislative intent of this law when it was passed in 2012. I cited in my testimony the committee report from the Judiciary and Labor Committee, which also stated that this measure creates uniform application and deters imprisoned offenders from incurring new offenses. What happened since the law was passed in 2020, the Hawaii Supreme Court in State versus Abihai was looking at this law and decided that the law did not do what the legislature intended for it to do. And so this bill is intended to correct that problem and achieve the legislative intent of this law. Thank you.
Thanks very much. Next is William Bento, Office of Public Defender. Good morning.
Chair and members of the committee, my name is William Bento. I'm an attorney from the Public Defender's Office. We respectfully oppose HB 2074. I've submitted written testimony, but I'd just like to touch upon a few points. If the purpose of the bill is to deny pre-sentence detention credit to those so situated, it causes two important problems. One, it is a violation of a person's right to a trial. The person who chooses to have a trial will not be sentenced as quickly as the person who changes their plea quickly, and thus is a violation of their right to a trial because they won't get that credit time that they've actually earned waiting for their trial. Also, it's a violation of the double jeopardy clause because your person earns the credit and then they're not able to use it for their minimum or maximum term and thus are required to serve that time twice. Now, I understand the purpose of the bill, but the way the language is written, wherein it says any periods of detention following arrest shall not be deducted, and I'm paraphrasing, shall not be deducted from the minimum and maximum terms of the sentence imposed on the later crime, actually creates a de facto consecutive sentencing scheme. And this is problematic because one, it removes judicial discretion from sentencing. Number two, it will increase the demand for trials because if a person cannot plea bargain or they're going to receive a consecutive sentence, they need to fight their case. Now, I just want to say one other thing. You know, what happens in these situations, you have people who commit violent crimes against other inmates or DPS employees. Now they're being treated the exact same way as the person who walks away from work furlough or returns late from work furlough because those people are still in custody and are charged with escape. They shouldn't be treated the same way. And judges currently have the ability to sentence people appropriately, and I'm available for questioning. Thank you.
Thank you very much. Next is Trisha Nakamatsu, Deputy Prosecuting Attorney for the City and County, or her designee. Good morning.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. The department stands in support of this bill as it does clarify the legislative intent from 2012. We'll be here for any questions. Thank you.
Thank you. Next, we have Director Otani from Hawaii Department of Public Safety and Support, and that's all the testimony we have on HB 2074. Members, any questions? Okay, seeing none, let's go ahead and move on to the next bill. Thank you, testifiers, for being here. Next bill is HB 2337. This clarifies the definitions of drugs, substance, and substance abuse for purposes of operating a vehicle under the influence of an intoxicant. First up on 2337. Andre Peters for Honolulu Police Department. Good morning.
Good morning, Chair, Vice Chair, committee members. Acting Captain Andre Peters on behalf of the Honolulu Police Department. We stand by our written testimony and support, and we'll be able to answer any questions.
Thank you. Next is Archie Cole for Mothers Against Drunk Driving. Good morning.
Good morning. Vice Chair, members of the committee, Archie Cale, member of the Public Policy Committee of Mothers Against Drunk Driving. I just want to read one paragraph of our written testimony. The constant changes in the production of legal and illegal drugs are rendering efforts to accurately identify them futile. With language more inclusive of natural and or synthetic impairing substances, HB 2337 will increase law enforcement's ability to make our roadways safer. I was thinking as I drove over here, if this had been written back in the days of long before these designer drugs, and it was about alcohol, you would have found bills that specified bourbon, gin, wine, and beer, for instance. And if somebody then got pulled over for impaired driving, but they had tequila, they had been using tequila, they wouldn't be prosecuted. That's the sort of situation we're in, and it's crazy. So let's try to make it broader. Thank you.
Thank you. Next is Director Butai for Department of Transportation and support. Amanda Guadarrama, Government Affairs Specialist for AAA Hawaii, American Automobile Association and support. And Matthew Cohen in opposition. That's all the testimony we have on HB 2337. Members, any questions on HB 2337? Okay, seeing none, I don't have any either. Let's go ahead and go to decision making. There's one bill that we need to discuss a little bit. That's the HB 2069 relating to the gifts.
Why don't we do it when we get to it?
Sorry.
Why don't we just do it when we get to it?
Okay, that's fine. Yeah, I don't think it's that controversial. We'll figure it out. All right, so we've already voted on the GM. Let's go ahead and go to HB 1471. This amends provisions relating to dates and deadlines and statutory provisions regarding, governing political parties. Recommendation here is to pass as is. We've passed a similar one on the Senate version. Questions or concerns? If not, Sergio Cololi.
Members, on voting on HB 1471 passing unamended, noting that all members of the committee are present. Are there any reservations? Any no votes? Recommendation adopted.
Thank you, members. Next up is HB 1472. This amends the information necessary for a voter to withdraw their signature from a petition. And as Mr. Nago noted, there's only two petitions. One is for qualifying political parties, and one is for putting a presidential candidate on the ballot. So the amendment would be to make it effective upon approval. Other than that, it looks fine. Questions or concerns? If not, Vice Chair.
Members, HB 1472 HD1 passing with amendments. Are there any reservations or no votes? Recommendation adopted.
Thank you. Next up is HB 2049. It's statutory revisions that crossed first, so we're looking at it again. Our recommendation is the same as in the Senate version. There were three sections that we felt were substantive as opposed to just clarifying. So we'd like to remove section 311 and 13. Questions or concerns? If not, Vice Chair.
Members, passing with amendments. Are there any reservations or no votes? Recommendation adopted.
Thank you. Next up is HB 2069. This is the protocol gift bill. So the recommendation is to be passed with some amendments. The reference to state employees will try to make that less ambiguous, and it will apply to all state employees. I don't know. I guess the question I have is, can we apply it to the judiciary, or is that its own thing? And not to put you on the spot.
Well, I'm thinking the chapter 84 definition. Any employee of the state, including members of boards, commissions, and committees, and employees under contract to the state, excluding legislators, delegates to a con, justices, and judges. So it would include judiciary employees.
Would.
It would.
Okay. All right.
It would not include a judge or justice.
They're the ones who are going to get the thing.
They have their own.
They're the ones that probably get the gift.
But they have their own.
But they don't take
policies.
policies. Yeah.
Okay. Well, why don't we just stick with that?
What about UH and schools? They're all considered employees, right?
Yes, they're under chapter 84.
Okay, so let's stick with that chapter 84 definition.
So we'll just say employees. You know, the bill says a state employee.
Okay.
Opposed to just
Okay,
employee.
so employees, but that will include the legislature as well, right?
Correct.
Okay. Okay, so we'll stick with that definition of employees, or we'll use that definition of employees. And then, I don't know, the gift reporting part of it, I mean, the way they described it, that makes sense, but I'm not sure that's what the bill actually says right now.
It modifies the gift reporting log exclusions. So all these gifts need to be reported unless it's a non-protocol gift that was returned. So protocol gifts, any protocol gift would need to be still reported under the current gift log statute.
Okay, so let's,
As well as whatever form JAG.
well, if it's okay with everybody, let's go ahead and exclude, let's get rid of that and just say that any protocol gift does not have to be reported on the regular gift log.
Because you're gonna
But
report it
because we
on.
have to report it to the,
Right.
to the parent.
Makes sense.
And then, so the question that Senator Kim raised, what I would suggest is, let's say it's a reasonable time that you have to you have to report immediately, so we'll keep that part of it in,
Right.
but
30 days.
make it a reasonable time as determined by the archives as to when you have to give them, to actually turn the gift over to them.
Okay.
But that for the legislature and specifically, that a reasonable time or no later than when you are leaving office. So if you've been in office for 10 years and you've kept it on your shelf that whole time because of your special relationship with some prefecture in Japan, then you can keep it there until you retire, and then you have to turn it over. But we'll give the power to the archives to say what's reasonable, but it can't be longer than you're in office if you're in the legislature. Oh, and actually, maybe you should say if you're an elected official. So that would be governor, lieutenant governor, just all elected officials except neighborhood board members.
So right now, it's just employee of legislative members. You want to broaden the application?
No, I was going to say that it's just a reasonable time for everybody.
It does not talk about the governor.
Yeah, there's employees already. So I'm talking about a special carve out for how long you can keep them if you're an elected official. So the elected official carve out would be a reasonable time as determined by the archives or when you leave office.
Okay.
Okay?
Sure.
Yes.
You want to then add a reporting requirement within 30 days? There's a record you keep that you would transfer with the gift, which is supposed to go within 30 days.
Yeah, I think
So now we need to
I think
add.
that's the way I understand it. She thinks it's going to work. So I guess we better put the reporting requirement in.
Reporting it within 30 days.
Yeah.
Okay, but then you get to hang on to it.
And we may need to do some committee reports to make that all sort of clear. Okay, clear enough?
It's my
All right, Vice Chair for the vote.
Members voting on HB 2069 HD2, the chair's recommendation is to pass this measure with amendments. Noting the presence of all members of the committee, are there any reservations? Any no votes? Recommendation adopted.
Now I'm thinking, did it have what was the date on this?
21/12.
Yeah, we'll just leave it. We'll go to conference and be sure that all makes sense. Okay, moving on to HB 2074, clarifies that the defendant shall not earn credit on a sentence imposed for subsequent conviction. Recommendation here is to go ahead and make it effective upon approval. Questions or concerns? If not, Vice Chair.
Members passing with amendments, are there any reservations or no votes?
No.
Reservation.
I have reservations for Senator Favela, a no vote for Senator Ocasio. All other members vote aye. Recommendation adopted.
Thank you. Next up is HB 2337. This clarifies the definition of drug, substance, and substance abuse for purposes of operating a motor vehicle. Recommendation is to pass as is. Questions or concerns? If not, Senator Kiyoko.
Members, HB 2337, HD1, passing unamended. Are there any members with reservations? Any opposition? Recommendation adopted.
Thank you very much. That concludes our business. We're adjourned.